Good morning. Happy Saturday. I've been thinking a lot about the is versus the ought. I heard it on a video recently, and it's a relatively simple statement, is versus ought. And it really sums up, I think, a lot of the contentions that people have in this little community. When I am telling you what the law is, I'm telling you what the law is, or what my best idea of what the law is and how the law is applied. I may be wrong, but it is me giving you the benefit of having been educated in the law and having read the cases and understanding the words that are in the cases and the context those words are being used in, and trying to digest it and spit it out to you in a easier to understand form. I may not always succeed at that, and I accept that, but that's my goal. And understand that I'm telling you what the law is, not what it ought to be, not what I want it to be. For example, the law is, if you're answering questions to a police officer, and then the officer asks you something that would incriminate you, and you just refuse to answer that question without specifically invoking your Fifth Amendment right to remain silent. And by invoking your Fifth Amendment right, you have to actually say, I'm invoking my Fifth Amendment right to remain silent. Then you're refusing to answer that specific question may be used against you. Now, in my estimation, that's a terrible fucking opinion. That is a terrible position for the law to have. It is outrageous that we've been telling people for years in TV shows and with Miranda warnings and all these other things that you have a right to remain silent. People aren't educated that they have to say, I'm invoking my Fifth Amendment right to remain silent if they have been answering questions and suddenly they refuse to answer further. Terrible fucking ruling. Terrible case law, terrible precedent. But that's the way it is. So, for example, I don't recommend trying to interrogate the police. And I don't recommend trying to interrogate the police, trying to demand that they answer your questions and do all these other things, because the police are better at verbal judo than you are. And, you know, hashtag not all. I'm sure that some people are pretty good at it, but the police do it a lot. They do it all the time. They do it every day. They're arguing with people who think that those people are smarter than the police. And they get the fucking answers that they want. They get the results that they want. People say incriminating things all the fucking time to police. It's amazing how stupid the common criminal is. So when you're out there and you're doing your demands of the police and you're trying to play the game and trying to show the police that you're in control, you're probably going to end up saying things or doing things or answering questions and then refusing to answer questions that you don't realize. Which is why attorneys will always tell you to shut your fucking pie hole. Shut up. Don't talk to the police. Cooperate. Do what the police tell you to do. And then let the courts sort it out. And again, people are like, oh, well, you have the right to... one guy posted a South Carolina Supreme Court case, right? You've got the right to resist unlawful arrest. It's axiomatic you have the right to resist an unlawful arrest, right? The irony wasn't lost on me that in that case, the person who was resisting the arrest, are you going to poop? He's going to poop. The person who was resisting arrest, who the court said it was axiomatic that that person had a right to resist unlawful arrest, the court ended up upholding the conviction for assault and battery with intent to kill against a police officer because the arrest wasn't unlawful. Hold on. Okay, bag of poop safely acquired, and we're back in business. And the irony of that situation isn't lost on attorneys either. And attorneys will never, ever recommend that you resist arrest because you are not the judge of what is or isn't an unlawful arrest. And 99.999 times out of 100, the person ends up getting arrested. If not then later. And 99.99 times out of 100, the person ends up getting, if they're charged with resisting arrest, or if they don't like negotiate away the resisting arrest, they end up getting convicted of that resisting arrest. And it is the rare exception, the infinitesimally small number of exceptions that people in this community try to latch onto, where the resistance actually was justified. And like, see, we can do it. I'm like, yeah, but you don't see all the motherfuckers who are killed trying to do that shit. And you don't see all the motherfuckers who are hurt doing that shit. And then convicted. They get the shit kicked out of them. And then they get convicted. They get shot and then they get convicted. Or they get buried. I mean, you know, neither way is terribly fun. But it's this whole thing of is versus ought. Do you have to roll down your window if a police orders you to? If the police order you to? Well, yeah, you probably do. You probably do. I mean, you're going to have to be a little more specific in that kind of question. You know, is this a suspicionless stop at a DUI checkpoint or an ID checkpoint? Some states you might not. Some states you might. It's going to depend on the state. But generally speaking, 99 times out of 100, if the police want you to roll down your window, you're probably going to have to fucking roll down your window or that shit's getting broken. How do we know that? Reality. Reality is going to slap its dick against your face and show you that, yes, indeed, the police can force you to roll down your window or they'll break it. Well, what's the justification of that? How do you reconcile that, legally speaking? Well, the police can order you out of the vehicle. Pennsylvania v. Mims, Maryland v. Madison. The police can order the driver and the occupants out of the vehicle for officer safety. If they can order you out of the vehicle, it's a balancing test, which I don't fucking like, but it is a balancing test. The state's needs versus the inconvenience to you. The court thought, well, you know, the state has a really big interest in officer safety, and it's a very small inconvenience to you to get out of the car. Well, imagine how much less of an inconvenience it is to you to reach your little index finger over to the button on your door panel and press the down window button. But then, like, why do we even have to go there? This is just fucking reality. Go to YouTube and look for broken window. You'll find thousands of sovereign citizen videos of them getting their windows busted out. All the time. Anyway, the point of this little ramblin' while amblin' video is that reality is going to exert itself no matter what your fantasy is. In Meth Mouse's world, he had a multi-million-dollar lawsuit against Best Buy. But then reality slapped its dick against Meth Mouse's urine jug in his garage where he lives. And he doesn't have a multi-million-dollar lawsuit against Best Buy. That's reality. You wish you could take down my YouTube channel. You wish you could get me fired. You wish you can get me disbarred. But then reality is going to slap its dick against your face and you're going to realize that you can't. These things are just... It's just really unfortunate that there are so many people who want to do the should be. The police should be required to articulate their specific facts that justify a detention to the detainee at the time of the detention. They should be required to do that, except they're not. And it wouldn't matter even if they did, because the police officer is not under oath. Nothing the police officer says can or will be used against him in the court of law. Police officers can lie. They can mislead suspects. It doesn't fucking matter. The suspect is not the judge of what is or is not a lawful or unlawful stop. It's just without use. It is a useless proposition based on a misunderstanding of the law, based on a misunderstanding of reality. Thinking that somehow, if the suspect thinks that somehow that it's unlawful or it's an unjustified stop, that suddenly gives the suspect the right to resist. And it doesn't. It's whether the judge thinks that it was an unlawful stop. Because in our system of law, the police don't act as judges, and the suspect or the defendant doesn't act as a judge. It is the judge who determines whether or not there was reasonable suspicion or probable cause, except in the grand jury indictment, in which case it would be the grand jury who determined probable cause, but you get the point. Anyway, thanks for watching. I hope everybody has a wonderful Saturday. Try to pay attention to reality. Oh, in other news, I don't know if it's made its way around, but Earl David Worden's trial was kicked out to May, so don't expect anything in March on him. It does appear that he did get the CPS records, him or his attorney. I'm assuming the CPS records were turned over to his attorney and that Earl's not being given direct access to them. Earl's probably allowed to look at them in the attorney's office, but not take them with him. So anyway, I feel bad for the whoever CPS records were turned over to Earl, but that does happen, and Earl does have a right to defense, and you know, he's not considered guilty in the eyes of the law until the jury comes back with the verdict on him. So keep that in mind. Thanks for watching. Have a great day.